From the daily list, item number 1.
May it please your lordship.
Yes.
My lord, the affidavit on behalf of respondent 2 has been filed, my lord.
You are appearing for respondent 2.
Yes, my lord. On behalf of conducting counsel, Mr. Philemon Nungri, my lord.
Speak a little louder.
My lord, I'm appearing on behalf of the conducting counsel, Mr. Philemon Nungri, my lord.
Who's for the petition?
My lord, if I'm not mistaken, my lord, he's before call number 2, my lord.
My lord, he's on legs in courtroom 2.
You start.
My lord,
What is this matter about?
This is for the plastic bar, my lord. It's a PIL.
The state has intensified its efforts to bring about this complete ban on the use of single-use plastics, Your Lordship.
But have you been able to
We have
introduce,
seized, we have
have you been able to introduce a substitute?
substitute, I substitute, by substitute, Your Lordship would mean?
Substitute for plastic?
Yes.
No, those
Otherwise-
paper bags are being used, Your Lordship. In most of the shops and all that, paper bags are being used, Your Lordship.
I would like to contradict to that, my lord. Just the other day, my lord, I went to buy a fruit just 200 meters away from the High Court, my lord. They were still using the plastic in spite of passing this order. I have sent a letter to the education institutes where I wanted to know, my lord, what are the government is implementing and how they are trying to help the education education institutes where the teachers and the students are taught the ill effects of plastic. How do we not to use this? I've written, I'm going to meeting all the principals in the coming weeks, my lord. But as on today says, whatever the reports that they have given from the authorities, very sorry to say that.
Once you start using paper, another PIL will come that you are cutting trees. A green friendly PIL will come.
No, my lord, that will not come because in Meghalaya, my lord, I'll just apprise, my lord, we have a leaf, my lord, where we call in a local sla jar, my lord. These are very even if you go to some restaurants today, my lord, they still practice their use, my lord. And this morning I was coming, my lord, I saw a truckload of those leaves, my lord, are going to Bara Bazaar, my lord, onward this thing. But this has to be capitalized and entrepreneurs need to be encouraged by the government to grow this kind of leaves, my lord. It's a very, so many things will come out, my lord.
That is all right, but a blanket ban,
Yes, my lord.
plastic has its own good effects also
Disadvantages.
as a use for containers, etc. But provided it does not create a health hazard,
Yes, my lord.
like in terms of very thin plastic bags choking the drain, choking the
Choking
river,
the drain. Yes, my lord. Yes.
etc. But
Yes, ma'am.
then this blanket ban short of a substitute
Yes,
is
ma'am.
not workable.
Now, my lord,
Doesn't seem to be workable.
my lord, what we expected the government is to, my lord, after the order, my lord, at least in a war footing, they will inform the public the ill effects of plastics, my lord. Not even one thing has come to that, my lord. So, my
I
lord,
have stated in my report, Your Lordship, what actions we have taken and that this is an ongoing process and we are intensifying our efforts to bring about a complete ban on plastic, Your Lordship, single-use plastic, Your Lordship. The thin plastics, as Your Lordship mentioned.
we have recently been to Bhutan, my lord. Bhutan, where my lords, we all, as a team, we have gone, my lord.
The public has to be educated on
Bhutan has not banned plastics, my lord. But all the major rivers passing through the capital, like a Thimphu or a Paro city, my lord, the big rivers, my lord, we did not find any bottle, any plastic floating there, my lord. Why? Because the administration
Yes,
is
that should be the that should be the cause of action.
Yes, my lord. So here, my lord, if there is a will, my lord, I still believe, my lord.
For example, Horlicks.
Horlicks.
Horlicks in a glass bottle,
Yes.
if it is made of glass,
Yeah.
plastic is banned.
Yes.
If it is made of glass, say will cost you 200 rupees. But if it is packed in a poly bag, it will cost you 130 rupees, say. Now, who's going to balance these equities? You just can't say plastic, ban. You have to see that what side effects, counter effects this ban is going to produce.
Yes. No, that is very much there, my lord. But then how, in what way, my lord? Then it has to come from the willingness of the administrative and efficient controlling, my lord.
Let us see your affidavit.
So this is at page, it's affidavit dated 30th/9/2024, Your Lordship. It was filed after the order dated 16/8/2024, Your Lordship. May I read, Your Lordship? At page 2, Your Lordship, the steps taken by the state in curtailing the use of plastic has been indicated, Your Lordship.
Page?
At page 2 of the affidavit,
Yes.
steps being taken by the state in curtailing the use of plastic. With the cooperation of the Central Pollution Control Board and the Shillong Municipal Board, Your Lordship, we have signed an agreement also with Dalmia Cement Limited on 10th January, whereby the board has been regularly transporting plastic waste that has been baled to be used as refuse-derived fuel in cement kilns, Your Lordship, at page para 3. In Your Lordship, at para 4, we have given a list of the inspections and raids and seizures made by our inspectors. And this is an ongoing process, Your Lordship. We are trying to intensify this effort to ban the use of plastic. And directions have also been issued to the temple authorities on the usage of plastic bags in and around the worshipping places, as had been directed by the order dated 16th August, Your Lordship. We've also attached photographs, Your Lordship, of the reads being conducted.
Yes,
Uh, so, my lord,
they are taking steps.
They are taking steps, my lord, but my lord, the pictures when you go around in the city, my lord, it shows a very different, it depicts a very different picture, my lord. They may be taking steps, but my lord, but is that enough, my lord? That is what the question comes now, my lord. Because when you say, my lord, everything is littered around, my lord. When we, as I was just saying, my lord, when we went to Bhutan, my lord, no plastic is burnt. But in the roadside, my lord, you will not find one piece of plastic being littered, my lord. My lord, we are a hill state. Besides the environmental, the ecological imbalance that is causing, besides that, my lord, go to any out of skirts, my lord, you will find all garbage is packed in a plastic and thrown, in spite of garbage vehicles coming every now and then, my lord. So, because the source is not being nipped, my lord. Now they're saying that 50 microns, 120 microns is okay. But that 50 and 120 microns is making the shopkeepers or the or whoever is responsible take an advantage because there's no ban in the plastic. I want to be very balanced, my lord, where if I say that, my lord, a complete ban of plastic may not be possible, my lord, but we can make an effort, my lord, to that.
That effort is being made, your lordship. I have been repeatedly saying that. We are intensifying our efforts, and your lordship, we have attached all the reports and the photographs to show what actions we have taken so far, your lordship. But this is a time-taking process. It is an ongoing process, your lordship. We cannot completely do away with it immediately, as my friend wishes, your lordship.
No, it's not my wish, my lord. It is all our. We are all.
It should be a joint effort, your lordship.
We are all.
My friend is insisting.
We are only fighting, or we are only trying to make something better for our next generations to come and thereafter to come, my lord. We don't want to leave a garbage full of plastics for our generations to come. This is all I aspire to persuade, my lords. Kannur, my lord, in Kerala, has been declared 2017 as a plastic-free state, my lord. Sikkim, my lord, is a good example, my lord.
So those
Bhutan is a good example. When they can do, why can't we do?
Say 200 milliliters of Coca-Cola
My lord.
in a canned bottle
Yes, my
will
lord.
be something, rupees something,
Yes,
and in a plastic bottle will be three
Yes.
times less.
Yes, my lord.
You have to consider all these things.
Yes, my lord.
So how could the people afford? Now everyday milk is sold in glass bottles, as they used to do 40 years ago.
Yes.
Would the poor people be able to buy it?
My lord, if not into that picture packaging of, my lord, also at
At
least.
that time, the glass bottles used to be delivered at the doorstep. Next morning, the milkman used to come and carry it away
Take it.
and
take
give
it
a
back.
fresh glass bottle.
Yes, my lord.
Now you get it from vendors,
Yes, my lord.
local retail outlets that you buy these
Yes.
poly bags of milk and all that. So it has to be balanced.
Yes, my lord. We'll have to identify, my lord, which is the most polluting to talking. Maybe many of time the plastics bottles, when we say the Coca-Cola bottles may not, because then I've seen also people make use creatively making walls and making so many beautiful creative arts out of that, my lord. But out of these plastics, my lord, that have been thrown in the road, what creative that I ask a question to myself, my lord. Apart from polluting and choking the rivers, and then
Yes, please take note. This public interest litigation urges this court to pass orders for total ban of plastic in the state of Meghalaya. Paragraph. While entertaining the writ on 16th August 2024, this bench, presided over by the then Chief Justice, inter alia, ordered the government of Meghalaya to take steps to ban plastic items in the state. Full stop. We find from the letter and spirit of the said order that till the time a substitute for plastic was found, to serve the purposes which the use of plastic items to serve the purposes which the plastic items are now fulfilling, comma, regulatory measures should be taken by the government. Paragraph. We have perused the affidavit affirmed by the Secretary to the Government of Meghalaya, Forest and Environment Department on 30th September 2024. Indicating the action taken in compliance with the said order. It appears from this report that the government has taken some steps, some policy decision to carry out plastic waste management and also some action taken to seize plastic containers and other materials. The said order of this bench was passed about 3 months ago. Full stop. Having considered the report of the government, we are of the view that some more time should be granted to them to fully implement the order. Paragraph, while doing so, we are constrained to make the following observations. Plastic is derived from polythene, polythene, comma, a poly, poly, methylene, methyylene. Considering its properties, it was at one point of time it was used and still used for storing materials, comma, in expensively. Full stop. It is widely used as containers, bags, bottles, and other storage materials. Next. Research has revealed research and experience have revealed that these plastic products have some very adverse impact on the ecosystem and environment. Full stop. Plastic wastes cannot be easily recycled. Full stop. The waste cannot be managed. No, it causes waste management problems. Full stop. It also affects the ecological balance and environment. Since plastic has a very long natural life, some of the dumping of plastic wastes in public places, in water bodies, and elsewhere chokes, CHOKES, chokes. The water bodies, the drainage system. And results in accumulation of undesirable, accumulation of garbage in public places. Paragraph. The government has evolved a general policy of banning the use of plastic materials with thickness less than 120
Yes, where's that plan?
millimeters.
75 microns thickness and 120 microns in thickness.
120 microns.
120 microns.
It has been increased to 120 from 70.
Yes, 120 microns. I'm sorry. Yes.
Less than 120 is banned.
Less than 120 is vandalism.
Yes. Paragraph till substitute or substitutes are evolved to take over completely the use of plastics in the market. The government is directed to follow the following policy. I to issue administrative orders or make or cause to be made legislation and or subordinate legislation effectively banning the use of manufacture, marketing and use of plastic of 120 microns or less to seize the materials less than 120 microns from manufacturers, distributors and users. 3, to take effective steps so that this waste is properly managed within a short period of time. 4, to make inspection of public places and recover these items and subject them to waste management. This will paragraph. The respondent number 2 is directed to file an additional affidavit in this court before the returnable date. A second additional affidavit. A second additional affidavit showing the action taken in terms of this order. We make this public interest litigation returnable on the first available day for these matters in the second week of March
Madam.
2025. All right.
Oblige, Your Lordships.
All right.
From supplementary list, item number 2.
Yes, please.
Milord, Sorry to interject, Malas, the court master has called out supply item number 2. There's a supplementary item number 1, Malas, with a very short matter, because the main issue has now been dealt with by a constitution bench of the Honorable Supreme
All
Court.
right, which matter?
You just close it, sir.
Limestone.
Limestone, my lord.
Limestone, Malas.
Justice, 9 judges bench, my lord. Justice Nagaratna's dissenting.
Dissenting order, Malas. It is 8:1.
Yes.
So the issue has been settled now, Malas. In that view of the matter, nothing survives in this writ petition before this Honorable Court, Malas.
You are for the writ petitioner.
I am for the writ petition.
And your lordship has recorded in the last order, your lordship,
All right.
this aspect. So this man.
May I draw your lordship's attention to the order dated 18/11/2024. Malas have recorded it.
This is the only matter in the list. This one and this. What is this one? This one was called just now. And any other matter in the list today? No. Okay. Yes. Yes, please take down. Mr. Paul Learned Counsel for the petitioner confirms that the issue raised in the writ has been decided by the Supreme Court by its 9-bench judgment on 25th July 2024 in, we'll find it here, mineral area versus so-and-so order. So reported in 2024 SSC Online SC 1796. Paragraph. Learned Counsel does not want to proceed with the writ petition. The writ petition is disposed of accordingly.
Highly obliged.
Item number 2.
Some miscellaneous cases are also there. Writ petition and the miscellaneous cases are disposed of.
It will take time.
This one. Okay.
May I leave of your lordship, because it's in the other matter will be taking lot of time. Leave your lordship to mention
Do
all
you have any short matter?
short matter, miss.
From the regular list.
Regular
Number 2 and 3. It's for orders.
Because
All right. What is the regular list?
From the daily list, item number 2 and 3.
What about one? Huh? Okay. How many matters are there? Yes.
lordship, this both the matters and other matter also there is friction 6. So may I pray your lordship that this matter can be disposed of finally after the vacation.
Because these appeals have already been admitted.
Admitted.
My lords, we were directed to secure 30% of the demand amount, which we have done to the satisfaction of the cantonment authorities, to the respondents. We've already deposited that amount. So this may be taken up for hearing sometime after the vacations, my lord.
As an appeal.
My lord, yes, writ appeal.
Delay condoned.
My lord, it's already been condoned.
Prepare an informal paper book.
So this is a writ appeal, my lord. Writ appeal.
Yes.
If lordships, we don't have that practice for preparing that.
You
I'll prepare.
you see that it will become very convenient.
Lordship,
You have an index papers, and it will be very convenient for the bench and the bar.
Lordship, lordship.
The appeal was admitted by an order dated 30th July 2024. Paragraph. Now, the appeal has to be heard out. Dispensing with. Appeal has to be heard out, full stop. All the parties are present before the court.
Lordship, there.
And apart from that, you lost it, 30% of the rent has been deposited.
Yes. All the parties are present before the court, are represented in court. Next, issuance and service of notice of appeal is dispensed with. Then that usual thing, advocate of record for the appellant will file an informal paper book. You file it by 17 December
Lordship.
and serve a copy on the learned advocate for the respondents at least 7 days before hearing of the appeal. List the appeal for hearing on the second working Monday of February 2025.
Much. A similar order for the next item as well. Item number
Similar order. All right. Identical separate order. Item number 2.
2 and 3. 2 and 3 minutes.
Deeply authorized.
This miscellaneous case?
The interim order was passed in the miscellaneous case itself, my lord. That may be kept alive for the time being.
Miscellaneous case can be disposed of.
My lord, as your lordship pleases. This is miss case number 31 of 2024. This is connected to WA 44.
Yes. Is 31 is disposed of. Full stop. The interim order passed therein is to continue till disposal of the appeal or until further order, whichever is earlier.
Lordship.
Item number 4.
No, the other one, it is miss case number 32.
32. No, item number, all hotspots you have made of the list today. But item number 4, 5 will not be taken up today. The fixed matter will be taken up.
My lord,
Yes.
in item number 5, my lord.
No, the next day. Today is not
I'm
possible.
understanding. I agree to it, my lord. Worship, since we are coming from outside, my lord, any date may be fixed. Both of us, we are thinking, but if it's possible, not inconvenient on 13th of December, my lord. Because they can only be disturbed.
Item number
5.
5.
Item 5.
Who's on the other side?
My lord, I am appearing for the other
Yes,
side.
call item number 5.
Item 5.
From tomorrow, there will be only one list. And in that list, there is taken of the weekly list. Weekly list so and so, date then followed by daily list. This is yes.
Yes, 13th December, if it is not inconvenient to your lordship, my lord.
Appeal is ready for hearing.
Yes, my lord. We are also ready.
What is this matter about?
This is a tender matter, my lord.
Sorry?
It is a tender matter, my lord. It's a tender matter. Tender was LOIs were issued, my lord. And then ultimately impending order are passed, debarring me for 2 years. And then also risk and cost factor also they are imposed, my lord, that. So it will take some time, my lord.
Appeal is ready for hearing.
Yes, my lord.
Is there any interim order to the appeal?
That's the interim order, my lord. This is stay order.
So here also you file paper books with the appeal.
Yes,
Make it
my-
convenient.
Yes, my lord.
Same type of order.
Paper 195.
This appeal has been admitted, full stop. An interim order has been passed, which is subsisting. Full stop. The interim order shall continue till disposal of the appeal or until further order, whichever is earlier. Next, we expedite hearing of the appeal, dispensing with all formalities. Then all the parties are present, notice, etc., dispense with. Informal paper book, same order. You file your paper book by 17th December, we will hear it.
My lord.
So, second Monday of February.
After the winter vacation, Kulli will come, my lord, and the lordship also will.
Yes, most welcome.
My lord, only my name may be kindly be shown, BK Singh for the respondent, my lord. I have missed this
Please
matter.
give your appearance.
Yes, my lord.
Thank you.
Obliged.
Any miscellaneous application to be disposed of? No.
No.
No, my
No,
lord, this order will cover everything, my lord.
Yes.
Obliged, my lord.
From supplementary list, item number 2.
Yes, please.
Yes, my lord. Lordship, I was placing the statutory rules, my lord, which is called, my lord, Installation, Regulation and Maintenance Weighbridge Rules, page 57, my lord, page 57 of the paper book, my lord. Rule 3, my lord.
Yes.
Rule 3, installation of weighing devices. The government may install and maintain by itself as many weigh bridges for the purpose of section 144 of the Act on such places as it may think necessary, or may allow private persons, body of persons, company, organizations to install and maintain such weigh bridges on payment of lease amount to be determined in each case by the government after calling the tender, provided that no lease shall be granted permission to any private person, body of persons, company or organization unless after fulfilling all requirements, all criteria as laid down in Rule 456 of these rules and permission from government in transport department is obtained. So Rule 3 of the weighbridge rules, my lord, made it,
The question, learned Advocate General, is that whether the commissioner was authorized by the government,
yes, my lord,
and even if he was not,
yes, my lord, whether
a private person could have proceeded on the basis of the presumption
Yes,
that any government act is done regularly.
yes, my lord, I am grateful, my lord.
Under 114 of the Evidence
I
Act.
am grateful, my lord. Kindly see Article 299 of the Constitution.
No, that is all right. In the name of the president, in the name of the governor,
And
etc.
the one aspect is also there in 299 that he should be authorized by the government.
Now, every citizen is to check this, that whether it is in the name of so-and-so, he is authorized, then the whole administration will collapse.
No, my lord, this Article 299 has got two salutary purposes, my lord. One is, my lord, that if the agreement is executed in name of the governor by an officer who is not authorized, Article 299 says, and there are four judgments of the Honorable Supreme Court in this aspect, my lord, saying that it will not be binding on the government, my lord, because the reasoning is, my lord, that if the officer is not authorized and he has signed the agreement on behalf of the government in the name of the governor, my lord, whether governor is bound by the act of an officer who is not authorized in law. Because, my lord, has seen Regulation 3. Regulation 3 says that it has to be by permission of the government. In a given case, my lord, if there is no permission by the government, an officer has acted without permission, whether the government is bound by the action of the officer, my lord, is the question which falls for your lordship's kind consideration, my lord. And 299, your lordship will kindly see, because 299 has been subject to interpretation, my lord. All contracts made in exercise of the executive power of the Union or of a state shall be expressed to be made by President or by the governor of the state as the case may be, and all such contracts and all assurances of property made in the exercise of such power, of that power, shall be executed on behalf of the President or the governor by such person and in such manner as he may direct or authorize, my lord. So requirement of Article 299 in my humble submission, my lord, is that there has to be direction or authorization And if there is no direction or authorization, the contract may not be binding on the government, my lord.
Yes.
The admitted fact is, my lord, that there was no authorization, and for that, my lord, I need to show two agreements, my lord. First agreement, the lordship kindly see, page 66. This is the agreement, my lord, executed on 7th December 2017, page 66 at the top, my lord, is the date. And, my lord, details are there. The governor of Meghalaya, represented by Commissioner Transport, the government which expression successor in office, etc., my lord, and your lordship may kindly come to page 67, paragraph 2, my lord. Whereas the licensee had, besides others, submitted his application for the said purpose, and his and her application having fulfilled all the stipulated criteria, was duly accepted by the government, and licensee was given permission to set up weighbridge at so and so place. So the permission was, this agreement, my lord, records that the permission was granted by the government, and pursuant to permission granted by government, the agreement was entered. My lord, this agreement, your lordship may kindly take note that it was for a period of 3 years up to December of 20, my lord. And the renewal at all, if the petitioner would have got it from 20 to 23, my lord. That he has already enjoyed 3 years from 20 to 23. That is on the second issue, my lord. But first issue is that, my lord, whether permission, and kindly see the second agreement, my lord, which is at page 87. Page 87 is the second agreement on which my friend is placing reliance, my lord.
Yes, please.
Page 87, my lord, is the agreement dated 1st June 2022. At page 87 top, my lord. And the relevant part, my lord, is page 89, my lord. Second paragraph. '89, my lord. Second paragraph, whereas the licensee is permitted to operate the weighbridge on terms and conditions contained in this agreement for a period of 3 years from this date of the agreement, my lord. Lordship has noticed that in the first agreement, it was clearly said that permission has been granted by the government to set up the weighbridge. In second agreement, this aspect has not at all been referred, my lord. Now kindly see the finding of learned single judge on this aspect, my lord. At page 318, my lord. 318, my lord, of the paper book, my lord. Finding of the learned single judge on this aspect, my lord. Paragraph, last 4 line, my lord, of page 318. A comparison of earlier agreement dated 7/12/2017 and new agreement dated 1st June 2022 has also revealed certain discrepancies, such as it nowhere reflects that agreement was renewed after due permission as envisaged in Rule 3, read with Rule 6 of the Weighbridge rules was granted. In agreement dated 1/6/2022, it simply puts the Governor of Meghalaya, represented by Commissioner Transport, Shillong, which expression so and so, no declaration exists as recorded in the initial agreement of 1/7/2017, wherein it has been stated the licensee was given permission to set up the weighbridge by the government. My lord, learned single judge takes note of the provisions, statutory provisions, my lord, and kindly see paragraph 15, my lord, of page 320, my lord. Paragraph 15, page 320, my lord. In this context, paragraph 15, reference can be made to the judgment in the case of so and so reported, my lord, and the judgment of the division bench of the erstwhile court, my lord, says that lease cannot be granted unless permission is granted by the government or permission has been granted renewed, my lord. On that judgment, the learned single judge relies, my lord. And then 16, paragraph 16, with regard to rules of executive business, my lord, at page 322, my lord. Therefore, as held in the above judgment about the necessity of fulfilling certain conditions as provided by the Weighbridge rule, agreement dated 1st June 2022, which does not contain the requirement as provided in Rule 6 or 7, it can safely be held that same was entered into without the sanction or permission of the competent authority. It is also important to note in the minutes of the meeting held on 2nd June 2010 of the government, annexed to the writ petition, which was chaired by the Chief Minister, a decision at para 5 thereof also established the procedure. Permission for setting up check gate on national highway should henceforth be given only with the recommendation of the state government and not from the head of department. As such, from the discussion above, it is clearly established that agreement entered into by Commissioner Transport with the writ petitioner, apart from being without any authority, is also vitiated for inaccurate and misleading interpretation of the order of the court. Then, Mark 17, my lord, on the writ petitioners has sought to make out a case that agreement dated 1st June 2022 entered into a statutory agreement with the within the definition of Article 299 of the Constitution of India, which would make it binding in nature. However, in view of the absence of any express authority sanctioning the renewal, Commissioner of Transport in entering into the agreement without being authorized under Article 299 of the Constitution of India cannot be said to have complied with it. It also may be noted herein that rules of executive business of the Government of State of Meghalaya has also stipulated that order of instrument of Government of State shall be expressed to be made in the name of Governor and shall be signed either by Chief Secretary, Principal Secretary, Commissioner Secretary or Secretary and Additional Secretary or such other officer as may be authorized by Government, and such signature shall be deemed to be proper authorization of such instrument. The absence of any authorization and also by operation of rules of executive business of the Government of Meghalaya thus renders the agreement invalid and unenforceable, and will not cloak the petitioner with any vested right or actionable claim for continuance on the basis of said agreement dated 1st June 2022, my lord. And on this aspect, my lord, learned single judge has referred to one judgment, my lord. have three authorities on this aspect, my lord, where Article 299 has been interpreted, my lord. First judgment, my lord, is 2015, 7 SCC, page 728, page 1 of the compilation, my lord. (2015) 7 SCC 728, my lord, and the relevant paragraph, my lord, is paragraph 53 at page 29. Paragraph 53, my lord, at page 29, my lord. (53) We have to keep in mind that contract in question is governed by the provisions of Article 299 of the Constitution. These are formal contracts made in the exercise of the executive power of the Union or of a state, as the case may be, and are made on behalf of the President or by the Governor, as the case may be. Further, these contracts are to be made by such person and in such manner as the President or Governor may direct or authorize. Thus, when a particular contract is entered into, novation has to be on the fulfillment of procedural requirements. So my case is, my lord, that if the contract is made in the name of governor or in the name of president, my lord, it has to be done by a person who is authorized. And if that person is not authorized, then it is not open to the person to say that that contract is binding on the government, my lord. Second judgment, my lord, is at page 42, my lord, Union of India versus NK Private Limited. Paragraph 8 of that judgment, my lord. Paragraph 8 at page 48, my lord. The crucial question which arises for determination is whether there was a concluded contract, and if there was one, whether the mandatory requirement of Article 299 of the Constitution for entering into valid and binding contract have been satisfied. It is now settled by this court that though the word expressed or executed in Article 299(1) might suggest that it should be a deed or a formal written contract, a binding contract by tender, an acceptance can also come into existence if the acceptance is by a person duly authorized on this behalf by the President of India. A contract, whether by a formal deed or otherwise by persons not authorized by President, cannot be binding and is absolutely void, my lord. My lord, I am placing emphasis on the last two lines of paragraph 8, my lord. That it says, my lord, otherwise by persons not authorized by the President, cannot be binding and is absolutely void, my lord. 9 is also, my lord, reiteration of the same thing, my lord. Then the learned single judge, my lord, has referred to the judgment of the recent judgment of the Honorable Supreme Court in 2023 8 SCC 226, my lord, at page 52, where the principles have been discussed in paragraph 12, my lord. At page 59, my lord. We first deal with the submission of learned ASG, Ms. Bhati, that the contract in the present case stands on different footing as entered into the name of President. Article 299 of the Constitution of India provides that all contract made in exercise of the executive power of Union shall be expressed to be made in the name of President. The phrase expressed to be made and the word executed are intended to mean that there must be a deed or contract in writing and executed by person duly authorized by President or Governor in that behalf. 13 is the rationale, my lord. The rationale of Article 299(1), as explained in Chaturbhuj Vitthal Das Jasani versus Mureswar Parasram, is that there must be a definite procedure according to which contract must be made by the agents of the government in order to bind the government. Otherwise, public funds may deplete by unauthorized or illegitimate contracts. It implies that contracts not couched in particular form stipulated in 299 cannot be enforced at the instance of any contracting party. So this is the paragraph, my lord. This is the requirement, my lord. So, having regard to the requirements of law, my lord, and requirement of statutory rules, and the agreement signed by the officer who is not authorized under Article 299 is not binding, my lord. One more aspect, if your lordship kindly see the prayer on the facts, my lord, prayer in the first writ petition, which is at page 51, my lord. This is the writ petition, first writ petition, and the prayer your lordship will find at page 51, small Roman 2, small Roman 1. Impugned letter dated 14 July 2023 issued by the Commissioner of Transport intimating the writ petitioner that the agreement for operation of weighbridge at Amsrin is extended up to 30th September 23 as conveyed by the government, my lord. This letter of, and then your lordship will take note of the second paragraph also. The impugned letter dated 1st August 2023 issued by Commissioner of Transport addressed to the writ petitioner returning the original copy of challan for second and third installment of annual fee for operation of weighbridge at Amsrin. So there are two letters which were impugned, my lord, letter of 14 July 23 and 1st August 23, my lord. And you see the letter at page 244, my lord. Letter of 14 July, my lord.
Page
244, my lord, a paper book, my lord. You are hereby informed that the agreement for operation of weighbridge at Amsrin is extended up to 30th September as conveyed by the government in letter dated 20th June 2023, my lord. This letter, my lord, 14 July is under challenge, which clearly and unequivocally refers to the letter of the government dated 20th June 2023. This letter of 20th June 2023 has not been challenged, nor, my lord, has been withdrawn. And the second impugned letter, my lord, your lordship will find the second impugned letter, my lord, is at page 113, my lord. With reference to the subject cited above, I am to return here with the original copy of challan dated Oh, your lordship is right. Practice of preparing paper book with index will help the bench and the bar both, because
That is the usual practice in appeals.
yes, my lord, that
Why it is not introduced here, I don't know.
because for example, my lord, in Supreme Court, what they say that first you place impugn order, then read counter, and then in serial order all documents in one and with detailed index, so that
Yes.
it can be easily referred.
Petition with page number, annexures with page number,
Yes.
opposition reply, then the impugned judgment,
Yes.
part 1, part 2 is memorandum of appeal, etc., etc.
Yes,
So,
yeah, yeah.
with,
That
with
practice-
page number. So you have a one kind of a book and you open and the matter. Otherwise, from file to file, file to file, file to file.
Yes, my lord.
At the trial stage, it is all right. Appeal stage, that is stays.
Required, and because that is a requirement also, and that is what we do is that we do the spiral bound, and so that
Yes, and if the paper books are voluminous, you prepare a convenience brief there.
convenience.
All relevant documents in one brief.
That
It makes the work easier.
and it is easy to remember also that is their convenience. Yes, my lord. Here that's why pages are jumbled up. Some pages in 283 and then 113. It should have been at page 113, my lord. And my lord, this is the return of challan. This order was also impugned, my lord. This order has never been recalled, my lord. What my friend has argued, my lord, that the previous order by the Commissioner Transport has been recalled. And in the first writ petition, my lord, the order was passed by learned single judge, my lord, which is not under challenge, my lord, before your lordship. May I place that order also, my lord? This, my lord, the order was challenging July order and 1st August order. 1st August order was never withdrawn, my lord, and the writ petition was disposed of in the light of the order passed in the second writ petition, my lord. This order has never been challenged, my lord. And the other order of the government, my lord, that of 20th June, my lord, has also not been put to challenge, my lord. At page 283 is the order of the government dated 20th June 2023, my lord. This the government order of 20th June, my lord, which was mentioned in first impugn at page 283, my lord, is the government order. My lord, this 283, my lord, which was to the knowledge of petitioner, as it clearly gets reference in the first impugn order, was never, because this is the order of the government, my lord. Government's PM Sangma, Deputy Secretary to Government of Meghalaya, writing to Commissioner of Transport, my lord, sir, I am directed to refer to your letter on the subject cited above. and to inform that government has conveyed its approval for extension of agreement up to 30th September only and no more extension beyond the mentioned date, my lord. This order was also not challenged, my lord. And your lordship has seen page the impugn order, my lord, at page 249. Sorry, 249 is the first order, my lord, and 244, my lord, is the second. 14 July 2023, which is referring to the order of government dated 20th June 2023. So, my submission are twofold, my lord. One, that the agreement is not binding because it is signed by a person who is not authorized under the statutory rules, my lord. So, Article 299, which has been relied by my friend, will not come to the rescue of his client, my lord. Second submission, my lord, is that the order of the government, that is the main order of the government, that is 20th June 2023, has never been challenged. Third submission is, my lord, that the order of the second impugn order has also not been challenged, and the writ and the relief has not been granted. In view of all these factors, my lord, the judgment and order of learned single judge merits no interference by this honorable court, my lord. That is my short submission.
Thank you, Mr. Advocate General.
And no permission has been obtained.
You complete tomorrow? Lodge. Any other bench? At 12:30? You will finish in 45 minutes?
No, I'll
45 minutes?
yes, it's right.
No, please finish it tomorrow.
Yes, I'll finish.
All right. Learned Advocate General concludes his arguments. List this appeal. We hear Mr. Sen on reply tomorrow, that is 22nd. Marked at 12:30 p.m.
Grateful, my lord.
Obligement.